Hammer, and today's class is on the residential listing agreement. This is one of those that I think is extra important because so many things can go wrong with a transaction if you don't get the listing agreement correct, including up to and including not getting paid when the sale closes. So, and I'm sure you all want to get paid when your sales close. Hold on a second. Alrighty. Okay. So beginning with this document you see on the screen, hopefully all of you are familiar with it. This is the disclosure regarding real estate agency relationships. Now, I'm going to explain the form to you, some of the issues regarding your fiduciary duty. Oh, and by the way, if you would like to download a copy of this prop document, you can click the link in the chat window, and that should get you a copy that you can save to your desktop or whatever. Anyway, back to the listing agreement. The first page of it. Now, this is the disclosure regarding real estate agency relationships. This is required by the California Civil Code. Doesn't matter if you're on the buy side, if you're on the sell side, or if it's dual agency, same form is used. Either the buyer is going to sign it or the seller is going to sign it. If you're representing both the buyer and the seller, you're going to have each of them sign one. But a few things that I wanted to point out to you on this document. This document explains to the seller the different types of agencies, and it explains to them what your role as their agent is depending on the circumstances. So if you just go out to a property to list their property, you are only going to be at that moment a seller's agent. If you are working with a buyer and you are writing offers for the buyer, you are a buyer's agent only. If you happen to be an agent and you listed this property and you're out at the property holding an open house, and some stranger walks in off the street, looks at it and says, "Oh, I love this place, I want to buy it," then you're representing, if you write the offer for that buyer, you're representing both the buyer and seller, and you have dual agency. And we'll go over those in a little bit more detail in a moment. But the one thing I wanted to point out to you here, you can see here that your duty, your fiduciary duty to the seller and to the buyer is almost identical. And the way it's written here, it is identical. You have a fiduciary duty of utmost care, integrity, honesty, and loyalty in your dealings with the seller. And if you're representing the buyer, it's the same thing. What does that mean? Well, among other things, it means you can't be doing self-dealing. In other words, let me give you an example of what that would be. You are representing a buyer, and that buyer tells you that they have a particular subdivision in the city of Sacramento that they're looking to buy. They have been waiting for this house, for a house in that subdivision, which is only like 2 streets. They've been waiting for a house to open up there, single-story home. It's a particular plan model, and they've been waiting for that for months and months and months to open up, because that would put them in an area that would allow their children to go to a specific school, which is a feeder school, blah, 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 blah. You spot a house that matches their perfect dream home come on the market, and it is priced at such a great price that you decide to buy that house for yourself. That would be a direct violation of your fiduciary duty that you owed to your buyer client. It would also be an ethics violation. But legally speaking, it's about you're violating your fiduciary duty. Another important thing that I want to point out is Has everybody been able to see this prop that I have on the screen?
I can see it.
Okay, I just got a message that said my screen is now visible. I wanted to make sure you've been able to see it up until now. The other thing that's really interesting here is under seller's agent and under buyer's agent, you notice there is a specific set of duties that you owe to the buyer and the seller both. And you see that referenced here and here. And if you look at number or letter B on each, it's identical. And what this says is that you owe a duty of honest and fair dealing and good faith to both parties. That doesn't mean that you have to make things easier for the other side of the transaction, but it means you have to you have to be honest, and you have to deal fairly with them and in good faith. Whether you're representing one side or the other, you owe that duty to both sides of the transaction. Okay, it's kind of like, you know, the golden rule: do unto others as you would have them do unto you. That kind of stuff. That's built into your duties as an agent, and it doesn't matter which side you're representing. Now, when I explain this document to a buyer or seller, I usually start off by saying this document is required by statute in California. It's required so that I am sure to explain to you the different types of agency being my relationship and my representation of you. In California, you can have three types. There's a seller's agent, a buyer's agent, and an agent that represents both the buyer and seller. And then I would say, if I'm representing the seller trying to get a listing at that point, I would say, you know, in this case right now, I'm a listing agent, so I represent only you, the seller. And then I explain to them, should I eventually represent a buyer that comes looking at the property and has interest, then it would move into dual agency. Now, here's the kicker with dual agency that I want to make sure y'all understand. And I'm bringing this up this week with even more importance and urgency, because over the last week, I had a situation involving three very experienced agents that, between the three agents, had closed in the last few years close to 400 deals. So it's not like it was their first transactions. Now, keep that in mind as I'm explaining this to you. If you are representing that situation I gave earlier, where you list a property and you're holding an open house and somebody walks in off the street, the brokerage you work for is the same brokerage that's going to be representing the buyer, because you are a member of both brokerages. So in that case, you are representing the seller, you are representing the buyer, because the buyer came in and asked you to write an offer for them. That's like dual agency 101, right? The other type of dual agency, and here would be the other example, at Keller Williams Sac Metro, that's the Natomas office, I believe we have right around 260 agents here. If let's just say I list a property and it's in the MLS and it's getting activity from various agents with various brokerages, and then one of the other 260 something agents in this office who I had not personally met, I might remember the name if I heard it, but if I saw the agent walking down the sidewalk, if I saw the agent walking through the halls, I wouldn't know that agent from Adam. Let's just say that agent has a buyer, and the buyer contacts that agent and says, I saw this on Zillow, or I saw this listing on realtor.com. It looks like it's listed out of your office. Can you arrange to get me in to see it? So that agent takes the client out, shows the property, the client loves it, and that agent writes an offer. Because it is two agents, both listing listing agent and one representing the buyer, even though those two agents have never met one another, they don't talk to each other, they don't go out for coffee together. If one heard the other's name, they might not even remember the name as somebody that works at their brokerage. But because their licenses are under the same brokerage, which in this example would be Keller Williams Sac Metro, or KW Natomas, or whatever DBA you want to use, because they're under the same corporate license number, that makes that transaction dual agency.
Agents.
And so, I'm sorry, was there a question?
No, I said dual agency. I just confirming.
Yes.
Sorry, repeating.
So when you are the buyer's agent and you are filling out your purchase contract, you want to make sure to check the appropriate boxes, noting that it is dual agency and both agents are representing both the buyer and the seller. Very important, because as I said, in the last week, we've had a situation where very experienced agents claimed they didn't realize that was also dual agency. And they checked that on the contracts that each of them one was representing the buyer, one was representing the seller, and they were both part of the same brokerage. Okay, that and to emphasize why that is such an important deal, the state of California and the Department of Real Estate has put a special level of importance on identifying who you are representing, because they feel it is so important to know if you're a buyer or a seller, who's got your back. And to some extent, when you're doing dual agency, there's almost a per se argument that could be made that you can't give 100% of your full representation and following through with your full fiduciary duty to both sides at the same time. And so therefore, DRE really, really, really cracks down on situations where you fail to disclose that you are working for both the buyer and the seller. And so it's really, really important to get this done right when you submit an offer and when you ratify that contract. All right, now, somebody have a question?
Yes, would that would that contract be void if you mark that it wasn't dual?
No, it's not a void contract. Parties, buyers or sellers, could make an argument that they would be justified in canceling, but the more likely it would be more likely that they could make an allegation of fraud against the real estate agent, because the real estate agent, you could argue, was trying to conceal the fact that they were representing both sides, and that the client was at a disadvantage because of that. So it can, if you make a mistake, it can be corrected by doing a confirmation of agency form. That's ZIP Forms AC. And if you do that right away, then you can, extricate yourself from the mistake.
Bruce, right away, like while you're still under contract?
Yes, while you are still under contract. You don't, once the escrow closes, you can't really do anything. Once the contract is closed, it's considered what they call executory. It's done. And it's too late to do any documents, get any signatures. And there are certain things like which we're not going to cover really in this class, but like an agent visual inspection disclosure. That is designed to protect the buyer, to give them an extra set of eyes to see things that maybe a professional that's in a real estate professional might notice that a buyer or seller wouldn't. And so those have to be completed and presented to the buyer during the buyer's inspection period. If you fail to do that, then the buyer may get extra time added on to their inspection period. So, and certainly, again, that's one of those things that has to be done timely, so that that the buyer is properly noticed as to maybe a material defect that you spot that they didn't notice. Okay. Now, agent representing both buyer and seller. That's the dual agency thing that we've just been talking about. One of the things that's really important to know is, agents love dual agency because they get commission on both sides of the transaction. And that's great. You'll earn it because you're going to be doing basically twice the work. But the thing that I want you to also understand is if you're an agent and you're representing two parties, a buyer and seller, as dual agent, and I'm referring to the dual agency where you are actually the agent. There's not two agents in your office. It is just you. If you're representing both sides, you're actually limited a little bit in terms of how far you can go to represent your client on either side. For example, if you know that a buyer is willing to pay more money than the listing price, you can't tell the seller that. And if you know that the seller is willing to take less money than the buyer is actually prepared to offer, you can't tell the other side that. So in some respects, it limits you. If you're only representing the buyer and the listing agent is, has diarrhea of the mouth and can't stop talking, and he slips and discloses to you that, oh gee, the sellers really need to get this place sold fast because they are they're buying a new Lennar home, and if they don't have this house under contract by the end of the week, Lennar is going to cancel their sale. If that agent, is doing a poor job of representing that seller and tells you that, you are free to factor that in with your buyer in doing your negotiations when you come up with an offer for the seller. Poor seller for relying on that agent with the blabbermouth, but you're not precluded from using that information as a bargaining point when you write your offer. But if you were representing both buyer and seller, that cannot be a conversation that you have with your buyer if you're representing the seller in that case. All right. As always, I underline this. If legal or tax advice is desired, make sure you point your client toward a competent professional. Do not try to give tax or legal advice. That'll get you in trouble faster than anything. And bottom of the form, working with the seller for a listing, you're going to check the seller boxes, have them sign. You're going to have the office DBA name. I use this one here. This is the corporate license number for this office. You notice this corporate license number is not my personal license number. My personal license number goes next to my name here. I sign here and date it. We have seen a lot of files come through compliance where they're listing my personal license number as the office license number. And that's another one of those mistakes that we have to use a confirmation of agency form to correct. Okay. The second page of the agency disclosure, this is the civil code version of what we just talked about. You don't have to go through this with your clients. This is information only. They can read it if they need help, falling asleep at night, but you don't have to explain this to them. It does have some interesting things on it, like it gives a definition of an agent. It gives a definition of what they consider the listing price to mean, and the offering price, and what's a seller, and what's a buyer, and so on and so forth. The next document, and I should tell you too, when you, for those of you who have not played around in zip forms yet, when you get ready to do a listing and you go in there and you select a residential listing agreement, you are going to get all of these other forms preloaded with the listing agreement. It's going to come in one form package. So whether it's a listing or a purchase contract, all of these forms are going to come with the actual document, with the actual listing or the purchase contract. And these are all required by the state. They're required by our office. So that this is the full package. We have a fair housing and discrimination advisory. I do a separate class on fair housing that I highly encourage you all to attend. That's a big hot button subject in California. And in fact, for our continuing education courses that we have to take in order to renew our real estate licenses, they have really beefed up the fair housing modules that you have to pass. So pay attention to this. I'll give you a couple tips or tidbits on this. And not just in California, throughout the country, fair housing is based on violations of the rights of a certain class of people. And there are many classes. As you can see here, there are classes based on race, age, citizenship, medical condition, disability, immigration status, color, sex, sexual orientation, blah, blah, blah. I'm not going to read them all. But there's a hodgepodge of 10, 12 different laws, statutory laws, as well as several constitutional amendments and case law. And they all come together either under federal, civil, or statutory law or constitutional law, and California statutory and constitutional law to make up the entire package of fair housing law. So while you might have one federal fair housing law that only names 7 classifications, you might have 3 more added through this law or through an amendment to another law, or via the 14th Amendment, substantive due process clause of the United States Constitution, and so on and so forth. So basically, the way fair housing laws should be thought about is if you do an action such as steering or block busting, virtually anybody that you do this to is potentially going to put you in violation of fair housing laws. And those 2 that I mentioned a second ago, steering and block busting, those are the 2 main ones that real estate agents can get into trouble with. And I've said this before, hopefully if you've been to my other classes, you've heard me say this. I don't believe that you guys wake up on any given morning and start off the day by saying to yourself, let me see who I can discriminate against today. That's just not going to happen. At least I don't think it is. Where you guys usually get into trouble is you do something out of ignorance that can get you into fair housing violations. I see somebody has a question. Who has a question? Hello?
Well, that was me, Melinda, but that was a while ago. I already asked it.
Oh, okay. Did I answer your question? I guess
Yes,
so.
sir.
Okay.
Yeah, sorry. It takes me a minute to unmute.
Oh, all right. Sorry. So let me give you just a couple of tidbits. The first violation, either channeling or steering, an example of that is where, you get you're out there doing your marketing, you are working with your contacts, you're working your database, maybe you're running some social media stuff, maybe you get a referral and you get this buyer. And the buyer, let's just say they're in the Bay Area, and they have heard, rightly so, that real estate, they live in San Francisco, they're renting, but they have heard that real estate in Sacramento is a lot cheaper. Well, duh. And so now that they can work at home, they're thinking, well, you know what? I don't have to commute to San Francisco. Let's just buy a family home in Sacramento. We'll move the wife, the 2 kids out here, and I can work from home. I can afford to buy a house, and everything's going to be, coming up roses for us. So they contact you, and you're doing your intake interview with them. You're trying to find out all the particulars. Number one, have they been pre-approved? What are they pre-approved to buy? What price are they looking for? Do they want a single-story home, a 2-story home? How many square feet? How many bedrooms? How many baths? Are they okay with an HOA, or do they want, no HOA? And then finally, you get to locations that they're looking for. And they say, first of all, well, look, we're from San Francisco. We've never really been to Sacramento, so we can't tell you. And you're sitting there and you're talking to them, and you believe that you're dealing with a racial minority, and you're thinking to yourself, well, I'm just going to start pinpointing properties in this area because I think that they're a racial minority and I think they would fit in well there. Well, that's a fair housing violation if you do something like that. The better way to deal with problems like this, where you have somebody that just legitimately doesn't know a city and they can't tell you where they want you to set up their searches for, the best way to do that is you've got all their other features that they're looking for. Set up searches with the other features. Don't limit it by area or by city, and let them know, look, you're going to get just a ton of listings being emailed to you. What I'd like you to do is take a look at those as they're coming through at first. And if you see some that interest you, let me know. And you can either come down here for the day, we can go visit a few of those and maybe narrow down the area a bit. Or if you have a need to be near a certain freeway, if you need close proximity to the airport, we might be able to limit them a little bit more for you, depending on those criteria. Or if you have a specific school district that you want to be in, that might help us limit it a little bit that way too. But you give us those factors, and then we can narrow the searches down for you to get you into an area that you feel that you want to be in. And eventually, once they see that they're just getting inundated with listings from all over the place, they will try to narrow that down for you or work with you to narrow it down. That's how you avoid the steering or channeling complaints that might be leveled against you if you are making assumptions as to where somebody should be living. In my fair housing class, there's an example of some actual fair housing violations that were done. And one of them, and it almost sounds like it's made up, but this is a legit fair housing violation that was substantiated against an agent. The agent stated to the buyer, Mr. Goldberg, I found the perfect house for you. It is 10 minutes from the synagogue. There's a lot of Jews that live around there, and I know you will fit in.
No way.
Yes way. That was an actual violation that was upheld.
I cannot.
Yeah. Another one, and this fell under the Americans with Disabilities Act. Gentleman with a wheelchair working with an agent trying to find a house. The agent basically told the buyer, I'm only looking for 1-story houses because I know you will not be able to deal with the stairs. Well, the fact of the matter is, the buyer was open to 2-story houses as long as it had a living suite and a bathroom downstairs, but he wanted a 2-story so he could have his family living with him upstairs. That was held to be a violation. So you can see by some of the example, well, maybe not the first example, but at least the second example, the agent was legit trying to help the buyer, but just didn't realize how easily you can get into trouble based on something you say.
Can I ask a question about that, Bruce?
Yeah.
So these are based on assumptions, right? So is it useful or part of our due diligence to ask other questions, kind of like, is it important, like saying instead of it being close to an airport, but like, is it important to be in a community where there's like stores that have certain kinds of foods like halal, or like kinds of foods that you can eat, and other ways to ask questions like that?
Yeah, I don't think that particular question would fall under a violation, but I will tell you, and this is, I learned something last week that I did not know about fair housing. And the thing I learned is I was doing my, I'm still doing it, but I did my fair housing module in my continuing education because my broker's license is up for renewal. And they had a whole series of things that you can and can't say in the study material. And one of them is you cannot reference in your marketing material, in your questions about being in proximity to a church or a synagogue or, you know, a mosque. You cannot have anything like that within the marketing or the comments that you're making about a property. So the fair housing police, you know, this is all stuff that they will look at. And it's best just to avoid as much as possible. Now, the question you asked, Amy, I don't think if you're asking that question, actually, now that I'm thinking about this, if you are sitting across from, you know, a person that looks like that's the kind of food that they would, you know, prefer, and you ask that question, I'm almost wondering if that wouldn't potentially put you in trouble.
Right, because that would be an assumption, but if they
ask you, that's a whole nother story.
Or if they share something like that, like I've had neighbors from other countries and they have different places they shop and stuff.
Right.
And so it's like important for them to be close to those, but in the marketing, we can't ask those questions. Would that also be included if we like had a buyer questionnaire for them to fill out with different questions?
Yeah, I definitely would not.
Okay.
You could ask a broad question. You could say something like, you know, are there certain types of markets or grocery outlets that you enjoy shopping at? You know, I think that an open-ended question like that would probably be okay, because that would elicit a response from them, not based on you talking about a particular race, creed, color, you know, nationality or anything like that. You know, I don't know that would be any different than asking somebody if they want to be near a Trader Joe's. Okay.
Gotcha. Thank you so
I
much.
have another question, Bruce.
Yeah.
So we're not to ask those questions or assume that. However, if our clients tell us that they need to be near a certain church or a certain school, we can definitely talk about it then.
If a client says to you, I want to be within 30 minutes of a Roman Catholic church, yes, you can then talk about it, and you can set your searches for that. I would still document it really well in your files that this was brought up by the client. Now, let's contrast that with a client who says to you, he's a white client, you know, the kind that's wearing the big American shirt, and you know, he's got Nazi tattoos on his arms, and he says something to the effect of, I don't want you to find any properties for me that are in, you know, areas with lots of Black people. you get a client like that, and my advice to you is to say,
See you later, buddy.
yeah, basically.
Okay,
That's that's the kind of client that's going to get you into trouble. And if you were to do that, then you would be violating fair housing law.
nobody wants to work with him anyways.
No. All right. I'm going to move on from here because we have a lot of stuff to cover and we've got an hour and 25 minutes left to get through it. This is one of our longer classes, this one and the purchase contract class. Right. One last thing I wanted to cover here. I mentioned channeling and steering. The other one is block busting. Block busting is one that you can get into trouble in real estate with. And that is essentially, you can think of it as trying to induce panic selling. And I actually experienced that in the early to mid 2000s. There was a husband and wife agent. Ironically, the husband was African American, and he was knocking on doors in Natomas Park. And there's a section of Natomas Park that the boundary is over there near the charter school on Del Paso. And right in back of all these houses, there's a big open field. The open field is still there to this day. It's about a quarter mile wide, and it's, I don't know, a mile or so, maybe a mile and a quarter long, and it runs between Del Paso and Elkhorn. And this Gomer was knocking on doors, and basically his spiel was something like this. Hey, my name is so-and-so. I'm with so-and-so Realty. I just wanted to make sure, I'm going around meeting the neighbors here, want to make sure you're aware that the city of Sacramento has just approved a low-income apartment complex that's going to be built right in back of your home on that big vacant field. And of course, once that's built and you know, all the tenants move in, you know, with low-income housing, crime is going to increase like crazy, and they're going to be right in back of your house. So if you were ever thinking of selling, now would be the time to do it. Obviously, to this day, they still haven't approved or built anything there, but that's what the agent was doing. I found out about it because I listed one of those houses, and the seller handed me this agent's business card and told me about it. But that would be a fair housing violation because you are blockbusting and trying to induce panic selling.
And lying, clearly.
And lying, and that's a no-no. All right. This next form here that comes in the package, it's the possible representation of more than one buyer or seller disclosure and consent, also known as the PRVS. This form basically it's to tell your client, look, we represent multiple buyers and sellers, and multiple buyers, we represent multiple sellers. If our buyer decides to buy the house over here instead of your house, don't get mad at us and sue us. We don't tell the buyer which house to buy. That is the buyer's choice. And this form was the result of a lawsuit involving Coldwell Banker in Southern California long time ago. But one of the great things about this form is it includes another warning about dual agency, explains that a little bit. And then there's this paragraph right here, which I think is really informative. And I think a lot of agents don't know or realize this. And what this says is, buyer is advised that seller or listing agent may disclose the existence, terms, or conditions of the buyer's offer unless all parties and their agents have signed a written confidentiality agreement. So it doesn't say that they have to disclose this information. It just says they can, unless a written confidentiality agreement is not submitted with the offer and agreed to by all parties. So, I think most agents go through their careers thinking if I submit an offer to a seller, the seller is prohibited from discussing the terms of my offer with anybody else. That is not the case unless a written confidentiality agreement is signed and agreed to. So just remember, if you're representing a buyer, you give an offer to a listing agent on behalf of your client. If you don't include a written confidentiality agreement, get that signed, the listing agent is free to leverage your offer against other buyers' offer in order to potentially ramp up the purchase price. Wire
I
fraud.
have so many questions, but I'll save them.
Save them till the end. If I can get a little extra time, I will try to answer them for you. Wire fraud and electronic funds transfer advisory. This form became necessary because there's a bunch of little trolls that sit in warehouses in other countries, in Nigeria and Russia and in the United States too, and they try to think up legitimate ways, not legitimate, they try to think up illegal ways of helping buyers and sellers part with their hard-earned money electronically. And so this is basically telling you, be careful who you're giving your account information out to, because these people are out there. And finally, we get to the residential listing agreement. First thing I want to point out, this is the header of the form. You don't see anywhere on this form that uses the word contract. You guys see that? The point I'm trying to make to you is a document doesn't have to say the word contract in order to be a binding contract. It has to have certain features included in it. So it has to have parties. So in this case, the parties to the contract are the sellers, Jim and Jill Jones, Keller Williams Realty, that's the brokerage. And I didn't put it on here, but it also has to have a starting and an ending date. Actually, technically, a contract has to have a term. In the form of this contract, that means a starting and ending date. It has to have subject matter. In this case, it would be 2620 Mabry Drive, Sacramento, California. Now, we also want you to put in the parcel number, because if there's ever a dispute on the address, the parcel number will also help identify the correct asset being sold. And then you have to have a price, and that's this. So if you have all of these features and you have it signed by the parties to be obligated, you have a valid contract. Why is that important for you guys to know? Well, the answer is simple. Once a residential listing agreement is signed by the buyers and signed by you as a once it's signed by the sellers and signed by you as a representative of the brokerage, you have a binding contract, which means the seller can't just say, well, it's not selling, I'm canceling. And you can't say, you know what, Mr. Jones, you are a pain in the ass to work with. I don't want to work with you anymore. I'm canceling the listing. Doesn't work that way. It takes two parties to sign and ratify this contract. It takes two parties to cancel this contract. So remember that when you get fed up to here in dealing with your client and you say, it's not worth the stress that you're putting me through, unless you can get them to agree to cancel, you can't just cancel. And then when you do cancel, you use a formal cancellation form to make sure it's done legally. Let's see here. If you are listing a mobile home, manufactured housing, yeah.
Sorry, isn't there something in the residential or the representation agreement that says one or either party can agree to cancel the relationship at
No.
any time? No.
Nope.
Oh.
Now there might be a clause in a buyer broker agreement, something like that. But I can't even say that's for sure. They just came out with a new one, and I can't tell you for sure if that's in there. But not in a residential listing agreement.
Gotcha.
Just like on a purchase contract, the seller can't just cancel. Buyer has to be in breach, and then there are certain actions that the seller has to take. Right? All right. Now, if you are listing a mobile home, you still use this form, but you're also going to check this box, and it's going to add in manufactured home listing agreement. That'll have some additional terms in it. If there's a probate sale, you're going to check this box. It's going to add in some additional forms for you. Now, going to section 3 on the form. This is what determines how you're going to get paid. So first of all, you notice seller agrees to pay broker as compensation for services, irrespective of agency relationships, either 5% of the listing price or nothing in this case. So if you're just listing the property and you're going to put a portion, let's just say in this example, total commission collected is going to be 5%, but you're going to advertise in MetroList 2.5% that's going to go to the buyer's agent or the cooperating agent. If you were going to do that scenario, then you would put 5%, the full amount right here. That's the full amount that the seller is going to be paying. You got to remember, though, to put an X right here. If you don't put this X right here, you cannot collect this 5% from the seller, which means because of the cooperation agreement that you promised to pay the buyer's agent 2.5%, if you don't put an X here, that 2.5% is going to be coming out of your pocket, and you're not going to get a commission from the seller. So make sure, actually, I shouldn't say that. You won't get a commission from the seller if the seller is smart enough to realize that you forgot to check the box before you signed it. So you're going to put an X here, put 5%, and then down, we're going to come down here real quick, and you put an X here under 3D1. You're going to put an X there and put your 2.5% that you're going to offer in the MLS out of the broker's compensation. So when the seller says they're going to pay 5%, they're really agreeing to pay that to our brokerage. And then out of that 5%, we are agreeing through our cooperative agreement with MetroList or the other MLS, we're agreeing to pay 2.5% of that, or half of that in this case, to the buyer's agent as payment for bringing the buyer and getting the deal closed. Right? Are you clear on that so far?
I think so.
Okay.
Yes.
All right. I put a little note here. There have been some agents that try to tack on a fee for the fee that they have to pay to their TC, and they put it in this little spot here. So what they might do is put, 5% of the list price and 350 as a and 350 regulatory compliance fee or TC fee or whatever you want to call it. Don't do that. That puts you in danger of violating RESPA. The way the government looks at your commissions and your TC fees are, if you choose to use a TC, that's a cost of doing business. You can't pass that on to the buyer. Buyer's getting no benefit from that because part of your job as a licensee is to process the full transaction. If you choose to outsource that to a TC, which I'm not saying is not a bad idea, I firmly believe that TCs can be a big benefit to you, helping you get through the transaction without making mistakes, and helping you to be able to handle a higher volume of business. But you can't pass that expense on to your buyer or seller. So don't put it there. Now, this is a exclusive authorization and right to sell agreement. What that means is if at any time during the term of the listing, that property is sold, you're due a commission. Doesn't matter if you find the buyer, doesn't matter if the seller finds a buyer, it doesn't matter if the seller's wife's third cousin removed finds a buyer and you never talk to that person. if somebody buys the home, you're entitled to a commission during that term. So this is the type of listing agreement that is preferred for you to use. This item here, item 2, where I wrote in, or I put in 90 calendar days, this is known as a protection clause. And what this means is, or the purpose of this is designed to protect you in the event that during the listing term, somebody looked at the property, they maybe they put an offer in and then they canceled, and then moved on, and you thought they moved on, and then the listing expired. Well, prior to the listing expiring, the seller had a conversation with this person when they were touring their home. And the seller said, hey, look, my listing's going to expire in a week. Don't make any offer before then, and I'll be able to, cut you a break on the price or whatever. And it would just be you and me dealing. After the expiration of the listing, this person comes out of the woodwork, buys the house, and you're basically frozen out of it. Well, assuming you meet certain criteria, if you have a number of days here, if within 90 calendar days, in this case, after the listing expires, somebody that you knew was shown the property during the term of the listing comes out of the woodwork and ends up buying that home, provided you have identified those people at the end of the listing agreement by using this form NPB, you are entitled to a commission. Now, I've been utilizing a protection clause for as long as they've had the ability to do this in the contract. Have I ever enforced one? Absolutely not. And now that, we have all the social media and stuff out here, I probably never would, but you do have an option to leverage that if you so desire. I just always figure there's another deal down the horizon, and I'd rather not have my name and a description of how I coerced my seller into paying me a commission, splattered all over the internet and social media, but that's just me. You can also get paid if the property is withdrawn from sale by the seller, or if it's conveyed, leased, rented, or otherwise transferred, or made unmarketable by a voluntary act of the seller during the listing period. So if the seller basically refuses to entertain offers, if the seller ghosts you once you've done your marketing, then you are still entitled to a commission. Again, I defer back to my comments on here as to whether I would want to do that or not. And then lastly, if the sale is prevented by say the buyer. So let's just say the buyer's under contract and they have waived all their contingencies. They're moving towards the close. And at the day before escrow is supposed to close, the buyer sends a cancellation notice. Oh, I had a bad dream about the property. I no longer want to buy it. Well, the liquidated damages clause of the contract would kick in, and if everybody does what they're supposed to do, the buyer is supposed to surrender their earnest money deposit to the seller. Well, in that instance, you would be entitled to 1/2 of the damages recovered from the seller. Now, personally, what I would probably do in this circumstance is I would say to the seller, look, Mr. Smith, this clown burned up, over a month of our marketing time while we were working to close escrow with him. I'm not sure if you're aware of this, but the contract actually, our listing agreement actually states that 1/2 of that earnest money deposit you just collected would typically belong to me and my brokerage. You know what, though? I would rather help you get the property sold. So would you be amenable to extending the listing by another 1.5 months or 2 months so we can get this property unloaded and out of your hands. That's probably the way I would handle that. But again, that's one of your choices. Now this section here, seller agrees to pay broker. I gave an example here. You have an out-of-state seller, an investor trying to sell the house, and you've been advancing $50 a month to have somebody cut the front lawn for the last 3 months. This would be a spot where you would make allowances for that, so you get reimbursed at the close of escrow. And then for out of the area agents, you have this section here. We talk about seller has been advised of broker's policy regarding cooperation with and the amount of cooperation offered to other brokers. This is the spot where you say how much of the total commission you're going to give to the buyer's agent. But that would be for agents that are part of your same MLS or that have cooperation agreements with your MLS. But what if you're dealing with an agent who is with an MLS, say in Southern California, they're not a member of MetroList, and he's going to put an offer in on your property? Well, if that agent is smart, he's going to complete a CBC form and send it to you before he sends you the offer. And that's where you're going to run it by your seller and you're going to sign it and basically agree to consider him a cooperating agent and pay him the commission that is referenced in our MLS. Now, if you're representing a buyer in a different area that does not use MetroList or does not participate with MetroList, you're going to want to do the same thing before you send that offer over to them, just to make sure you're going to get paid. Otherwise, there is no obligation for that agent to ensure that you get paid your commission at the close of escrow. Now, I should probably tell you, having been in the business for a long time, would I not pay another agent their commission because they didn't send me a CBC? No, I'm not. I wouldn't play those games. But that's not to say that it isn't your legal right if you wanted to. So just to be clear on that. But people in this business have a long memory. And so, I can tell you agents that I had horrible transactions with that I thought were just the scum of the earth from 25, 30 years ago. I still remember their names. So, those are the people I try to avoid working with. Seller hereby irrevocably assigns to broker the above compensation from seller's funds and proceeds in escrow. So this is your assurance that if it closes, you and the other side are going to get paid, and it assures you that the funds are going to come from the seller's proceeds at the sale, and that's part of your contract with the seller. Here under F, they are representing that they have not previously entered into a listing agreement with another broker, unless they specify here. And you'd like them to go back at least a year if they have, naming those brokerages. Seller warrants that seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to the following individuals. And here's where they would refer back to the names in this NPB form if one was given to them. Make sure your seller signs or initials at the bottom of each page. Top of the next page, we have items excluded and included. What you want to do here is if there is any, so there's a couple things that I guess you need to think about here. First of all, as I said, this is your agreement with the seller. Whatever you have in this agreement is going to be put in the MLS for all the agents to see. Now, think about this for a second. When a buyer or when a buyer's agent sees this listing in the MLS, hopefully you would have been smart enough to put in the confidential remarks or in a checkbox everything that is represented here. For example, the fountain feature in the backyard is excluded. For example, the freestanding stove, which is considered actually personal property, which is why we want to reference that on the listing agreement. The freestanding stove, refrigerator, washer, and dryer, all of these items are considered personal property and would not normally convey with a piece of real estate. But you want to make it clear that these ones are going to be conveying with the real estate. And so in order for that to happen, there's a few things that need to occur. One is you have an agreement with the seller, this listing agreement, that the stove, refrigerator, washer, and dryer are to be conveyed as part of the sale, that the fountain feature in the backyard is excluded from the sale. Now, when you put it in the MLS, you're going to want to put these notes in the confidential remarks. There's also check boxes you can check that the refrigerator, washer, and dryer, and the stove are included in the sale. But think of it this way. The multiple listing service is not a contract between the buyer and seller. So if the buyer's agent writes up an offer and tenders it to the seller, because the buyer's agent would have seen, had they read the MLS confidential remarks and looked at what boxes were checked, buyer's agent would have seen that it is the seller's intent to include the stove, refrigerator, washer, and dryer with the sale, and to not include the fountain feature. Now, the fountain feature arguably could be personal property and you wouldn't need to include that. But when the buyer's agent writes up the offer, the smart thing to do is to take this stuff and put these into the actual purchase contract. That way, you make it part of the agreement between the buyer and the seller that the fountain feature in the backyard is excluded, the freestanding stove, refrigerator, washer, and dryer are included without warranty. That way, when escrow closes, actually, let me rephrase this. If you don't put it into the contract, and if the listing agent misses it when they see the contract and have the seller sign it, let's just look at the aspect of the refrigerator, washer, and dryer. If this was not put into the contract as included, then the seller packs up and leaves. They leave the refrigerator, washer, and dryer in the house. Buyer shows up on day of closing with their own refrigerator, washer, and dryer. And now they have these extra appliances sitting in the house because the seller had no obligation to remove them when they moved out. That's the kind of problem you want to avoid by making sure that the contract between buyer and seller is accurate and expresses the terms of the sale that were laid out. The objects that would be included in the sale as laid out in the MLS. And then the MLS needs to track back to the listing agreement. Clear on that? If I don't hear anything, I'll assume yes. All right. All right. Leased or not owned items. The big one that you're going to come in contact with is the solar power systems. There is a new form for you to include with your offer if you're on the buy side, and that same form is to be used by the seller on the list side, and that's called the SOLAR, solar form. First page of it gives a great explanation of the different ways of having a solar system, leasing, buying, et cetera, et cetera. The second page has some basic questions about the solar system on that particular house. Talks about if there's financing, who's the lender on it, who's the leaseholder on it, types of loans, that sort of thing. So if you're listing a house, you want to include the solar form, get that filled out by your client. If you're representing a buyer, you want to either get a copy of that form that the listing agent had the seller filled out. If you don't, then send one over to the listing agent and ask them to have the seller fill it out during your inspection period. Because there may be a loan that you need to assume, maybe you want the seller to pay something off, all of that stuff, but you're not going to know unless you have the information at your hands to do the research. Now, the other important aspect here is if you are representing a buyer and you're putting an offer in on a home with a PACE loan, which is one of the loans typically used to finance solar systems, if your buyer is using an FHA or a VA loan to purchase, they may have a problem. And the reason is PACE loans affect title differently than other types of loans. And it is not compatible with the FHA mortgage insurance or VA loan guarantee. So if you're making a loan, if you're making an offer on a home representing a buyer, making an offer on a home where there is a solar system, and your buyer is a VA or FHA buyer, you might want to try to negotiate in that contract that the seller is to pay off that loan. That way, it wouldn't matter if you've got a VA or an FHA buyer, as long as the loan is paid off by close of escrow or at close of escrow. All righty. Multiple listing service. It pains me to say that this whole section right here had to be added because so many agents, in trying to double end deals and find the buyer for their property themselves, had been recommending to sellers to exclude their property from the MLS. My take on this is you're doing your seller a disservice if you convince them to exclude their property from the multiple listing service. It is self-dealing at its finest. You get the most competition and the most exposure to a client's property by putting it in the MLS and letting the 7,500 members of MetroList, as well as all the buyers that get to see the feeds onto Realtor.com and Zillow and all those other sites, to get interest in your property and build up the potential for multiple offers or over asking offers. You don't get that same activity when you have an agent that's trying to double end a deal and deal only with their own little book of investors or buyers. So there are a couple legitimate reasons that sometimes a seller does not want the property in the MLS. Couple that come to mind. If the sellers, maybe it's a husband and wife, they're getting a divorce. They don't want the neighbors to know that they're getting a divorce. Or maybe they're in a financial bind for some reason and they have to sell the property and they don't want their neighbors to know. But there's very few reasons like that would justify keeping a property out of the MLS. So they've added these two sections into the form. Describes what an MLS is, what information is going to be provided. It talks about who our MLS is that we're going to use for their listing. In this case, it would be MetroList MLS. And then there's a whole section here that talks about the benefits of using the MLS and the impact of opting out. And it has a spot for the seller to initial, to acknowledge that they've read this and understand it. And then you as the agent, or us as a brokerage, generally you as the agent in the field, if you're listing a house, you're going to initial here. Moving on to section 7, there is a statement here about the clear cooperation policy. Basically, several years ago, NAR came up with this thing called the clear cooperation policy. At the time, Dave Tanner, who is the former CEO of SAR, and he was an executive with MetroList. He's also a real estate lawyer and a broker. He predicted that NAR's clear cooperation policy was going to result in a lot of associations and MLSs getting sued in class action lawsuits. And one of the reasons is it requires entry into the MLS as an active listing within 1 business day of taking the listing. Our MLS has a rule of we give up to 3 days, but that was one of many reasons for this. Anyway, Dave opted to recommend, and they took his recommendation to not join in on the clear cooperation policy. In the years that have passed, what he thought would happen did happen. And there are multiple associations and MLSs that are still to this day embroiled in class action lawsuits because of their adoption of the clear cooperation policy. And so when you do your listing agreement under 7A, you're going to put an X right here that says MLS rules do not require blah, 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 blah under clear cooperation. And then you are going to go to paragraph F, and you're going to put another X there because the clear cooperation policy does not apply. If you have a situation where you are going to not put a property in the MLS either right away or at all, you're also going to check this box here, and you're going to include a MetroList waiver to exclude that property for a period of time. That has to be signed by the seller. You can get that form by logging on to MetroList and then going to the forms link, and you will find it there. All right, moving on. This tells people that MLS data is going to go out on the internet. It's going to be made available at various internet sites that get syndicated out. Let's see. Seller representations. So first of all, I'm going to tell you why this is important for your client to understand. And well, let me just start with that. So this section says seller represents that unless otherwise specified in writing, they are unaware of various things. What are these things? They're things like, gee, has my bank filed a notice of default against the property? That's important because if they filed a notice of default, that means that they have initiated foreclosure against the property. Well, then you have to, do some research. Do you want to list a property that is potentially about to be foreclosed on? What happens if you get a buyer on the property and it gets foreclosed before that buyer closes escrow? Then you have all sorts of issues that can come up. If the seller has just or is about to file bankruptcy, that would prevent the seller from selling the property, which means if you go into contract, that contract is going to be delayed if it can close at all. If the government is investigating the seller, if there's litigation, if there's a lawsuit, somebody could file a lis pendens on the property, which would cloud title. If there's an IRS tax lien that's been filed against the property, any of these types of things, if it's, say you're dealing with spouses, man, woman, they're all legal here in California. If there is a divorce that's being contemplated, the first action done in a divorce, whether that's a separation or it's a dissolution of marriage document, comes with about 13 different automatic stays. One of those automatic stays prohibits listing and selling any real estate. So if any of these things are about to happen, you want to have this, important discussion with your seller to let them know that it would be a problem to try to sell your property right now. Broker and seller's duty, we have to exercise reasonable effort and due diligence to get the property sold. We agree to present all offers received in the seller's property and present them as soon as possible. That means if you take it to the extreme, let's just say today, I'm representing you as the seller, and today you accepted an offer from some agent and their buyer, and we now have a pending sale. Well, tomorrow you receive another offer on that property, and that offer could be higher or lower, it doesn't matter. You are still legally obligated to present that offer to your seller as soon as possible, unless your seller gives you written instruction that they do not want you to present any additional offers. So even if it's a pending sale and you get another offer, you got to present it. Now, if you're doing your job as their agent, you're going to have that, come to Jesus moment with them, and you're going to say, look, California law says I have to present this offer to you, but I also, as your agent, need to warn you that you are already under contract to sell your property. You have a binding contract to sell. And if you are considering, breaching that contract to accept another buyer's offer, even though that new offer is $25,000 more, I have to recommend to you that you should talk to a real estate lawyer before doing so. I can't give you legal advice, but there are so many bad things that can happen. You really need to get legal counsel before you accept that second offer. That's about the most you can do, unless, of course, you have a law license. And then there's other issues you have to deal with. But you can't be under contract to two people at the same time to sell your property, because you're going to be in breach on one of them. And so that's the best advice you can give your client, even though, as I said, you are required to turn over all offers to them. Buyer's supplemental offer letters. This is a big deal. And I'll confess that I used to use them. My partner and I used to use them all the time. I've used one myself on a house that I bought, the last house I bought in the Bay Area. Essentially, a buyer letter is, let's just say I'm representing one of you in buying a house. We know we have a lot of competition. So I have you write this wonderful letter about how you and your husband or wife are so thrilled to have an opportunity to buy, this wonderful home. We look forward to spending the rest of our lives here and raise our children and, have our grandchildren over and blah, 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 blah. And then you include this beautiful family photo that you include with it. And you put that on top of the offer that you send over to the listing agent. Well, I did this on my last house in the Bay Area. We had a 3 or 4 year old son, and we included a wonderful family photo with Daniel, and Daniel kind of signed his name at the bottom, talking about, how we're going to raise our, enjoy his childhood there and all this crap. We actually got the house, and we weren't the highest offer. So they can work. Here's the problem, though. There are a lot of folks out there that could potentially listen to the narrative that you or your agent have written, you or the buyer have written about the buyers, or can look at the photo and maybe see characteristics that would allow the seller to violate fair housing laws and discriminate against somebody because maybe the seller doesn't like African Americans, and that does happen. And so, a couple of years ago, they came out with this warning about buyer letters, and they finally built it into the listing agreement. Now, the way this works is it talks about why this could be a fair housing violation. And then on paragraph 2, the default is seller instructs broker not to present buyer letters, whether submitted with an offer or separately at a different time. Seller authorizes broker to specify in the MLS that buyer letters will not be presented to seller. That is the default. The only way that changes is if the seller overrides your instructions and puts an X here, which says seller instructs buyer to present buyer letters. Then if that happens, you get an additional warning from the broker, you representing the brokerage. Broker advises seller that buyer letters may contain information about protected classes or characteristics, and such information should not be used in seller's decision of whether to accept, reject, or counter a buyer's offer. And if seller relies on buyer's letters, seller is acting against broker's advice and should seek the advice of counsel before doing so. So we have done everything possible to allow that client to protect themselves and for you to protect yourself. And I hope you can see that all here. Here, if you are one of those agents that prefers to do pre-listing inspections on your homes, this is where you can build that into the listing agreement. I personally, I'm old school. I like doing inspections. I like having the buyer do the inspections after we're under contract. That way, in my view, the seller and me, their agent, has plausible deniability as to anything, any factors that wouldn't normally be visible or normally would show themselves up until the point that the buyer's inspection comes along. I can tell you when I was in the Bay Area years ago, it was very common. The norm was for sellers to do pre-listing inspections. And there are more and more agents out here in the Valley that are starting to do pre-listing inspections. So there's no right or wrong answer to this. It's just whatever you decide that you want to have a discussion with your seller as to how they want to handle it. This section here, I want to bring this up so you're not misled by this. Under deposit, broker is authorized to accept and hold on seller's behalf any deposits to be applied towards the purchase price. As to our brokerage and most brokerages, agents do not take checks from buyers for earnest money deposits. They do not take cash. They do not take cashier's checks. If you were to take a check from your client, it would have to be entered into a check trust log until such time as the offer was accepted and the check was released to the title company. If you fail to do that, it's a DRE violation. So the purchase contract has now been written so that the default is within 3 days of going under contract, the buyer will wire their funds to the title company. So even though you are authorized by this listing agreement to accept earnest money deposits from buyer's sides, you will not do so. Just remember that. Get you into trouble. Talks again within the listing agreement about dual agency. Security, insurance, showings, audio, and video. When you list a home, part of your script or your spiel should always include a segment on, you want to tell the sellers, look, once, and this goes for paragraph 13, 14, and 15. Once your home is listed, ideally, you're going to be able to put a lockbox on the property so it can be shown, have the most opportunity to get shown. Your photos of your house are going to be blasted throughout the internet. So looking towards that day when we start all of our marketing, Mr. and Mrs. Seller, if you have a Picasso on the wall, you probably want to remove that. Once you're listed and people are coming into your house, you want to make sure that you're not leaving any tax documents out and about, no checkbooks, no jewelry. Don't leave your computer open and unlocked. If you have any weapons or firearms in the house, make sure they're in a gun safe or bring them over to somebody else's house for storage while the house is being listed. Just take proper precautions. Don't cancel your homeowner's insurance until escrow closes and we give you the good news that the deed has recorded. so on and so forth. And just make it clear to them that, if something goes missing during the listing period, we are not liable for that. And there is stuff in the listing agreement that says that. Very important. The worst situations you will ever have listing a property is when it is tenant occupied. Tenants love to ensure that you can't sell the property they're in. At least that's the norm. You might get an outlier who's friendly and is willing to work with you. But the problem is tenants don't like to be displaced. They don't want to have to move. And there's always that unknown when you list a property that is tenant occupied as to what they're going to have to do. Some of the worst transactions I've ever had were tenant occupied properties. You give them the expectation when your photographer shows up, a week from Tuesday to do the photos, and you show up there and there is a 3-foot stack of dirty dishes in the kitchen sink, and it looks like they just fed an army. They will just do their best to make it impossible for you to sell. So that being said, when at all possible, get the seller to get the tenants out of the property first, then list it. Now, I recognize that cannot always be done. So a couple things to note. When you are listing a property that's tenant occupied, you're going to want to have a form. It's called a key safe and lockbox agreement. You're going to want to get that signed. And the tenant will sign that, agreeing that you can enter the property or access the property. And there's going to be appropriate notice requirements that may need to be made, 24-hour notice, that sort of thing for showings, blah, blah, blah. Remember that the seller is responsible for getting the tenant's permission to put a lockbox or a key, Supra on the property, not you. So the seller is responsible for doing that. And also keep in mind that without that form and without permission from the tenant to enter the property or come onto the property, you are actually a trespasser if you step anywhere on the property line. That means if you put 1 foot within the boundaries of that lot in order to install a for sale sign, or if you walk up to their front door to put a lockbox up there or something without the tenant's permission, you're trespassing. So it's really important that you involve the seller. And if you have a tenant that's going to be there while you're trying to sell it, involve the seller and get buy-in from the tenant so you can do what you need to do. Let's see here. This is kind of an important little paragraph right here. Does this mean that every time you take a listing, you're supposed to, hunt me down or hunt John down and get approval for the listing? Absolutely not. This is here for your protection. And what this means, the reason we have this is, you remember early on in this class, I talked to you about this being a contract. It takes 2 people to initiate it, the sellers and the broker, or in your case, the agent. And it takes 2 people to cancel, the seller and the agent or broker. Well, this gives us a little bit of latitude. So let's just say, for example, that, let's just say, for example, that when you filled out the listing agreement, it was your first one that you were doing, you got a little nervous, and you put your 5% that you were going to charge the seller in total right here. And then you also went and put 5% here. Or let's just say you did it 5% and 2.5%, but you forgot to check the little boxes here. So basically, you have a listing agreement where the seller is not obligated to pay anything at close of escrow. Well, our office policy says that you need to turn your documents in within 3 days. If you turn them in on time and they they were to get reviewed by compliance on day 4, you still have 1 day of grace in order to get a new agreement done with the seller, or an addendum to this agreement done with the seller acknowledging those corrections before we are not obligated to go through with it, because you have that 5 days after execution. So this is here for your protection and for our protection. Dispute resolution, another big section. These contracts are built in with a requirement for mediation and arbitration. And what that, for those of you who don't know, a mediator is not a judge, it's not a jury, it's not anything like that. Basically, it's an impartial third party. Usually they're retired attorneys, or real estate attorneys, or judges. Sometimes they're active, sometimes they're not. And basically, the seller and the broker goes in and meets with the mediator. That can be done these days. We've done them via Zoom. I've done a couple via Zoom, actually, rather than going into an office. And the mediator just tries to come to an agreement through negotiation with both sides. Nothing they say is neither side has to take direction from them. They have no legal force and effect to make you do something. They just try to reason based on what the law is and what the contract says, who's going to win if it ends up going to court, or ends up going to arbitration. And they try to get the parties to come to an agreement and settle. If the parties agree, they put together a settlement agreement that would be binding in court, and both parties agree to that, and it's the end of the game. If they don't agree, then it can go to potentially to arbitration. And if it goes to arbitration, then the arbitrator will act as a judge, and they will make a ruling, much like what you would find in small claims court. Usually disputes on listings are the types of things that could probably be handled in small claims court, which would actually be a lot less expensive than an arbitrator would normally be, because small claims court, you can't bring an attorney with you. So that's how the dispute resolution portion of this is handled. I wanted to point out paragraph 23 to you. You probably see this type of clause in a lot of agreements that you sign throughout your life, even to this day, where it says, this is the entire agreement. All prior discussions, negotiations, and agreements between the parties concerning the subject matter of this agreement are superseded by this agreement, which constitutes the entire contract and a complete and exclusive expression of their agreement. And it can't be contradicted by evidence of any prior agreement or contemporaneous oral agreement. This is known as a merger clause. And what this says is, if you and the seller made some other representation or some other commitment that did not get included in this listing agreement, it is not part of the contract. So let me give you an example. If, let's just say you took this listing agreement, and you recall on the first page of it, we said we're going to charge a total of 5%, of which we're going to give 2.5% to the buyer's agent. Let's just say the seller said to you, as you were discussing all the different types of agency, I'll tell you what, we'll do 5 and 2.5, just like we discussed. But what about if you bring in the buyer and you're going to be doing both sides of it? Can we agree that in that circumstance, you'll only charge me a total of 4% instead of 5%? And you say, sure, I'm agreeable to that. But you fail to put that in writing within the listing agreement under other terms, other notes. That is not legally binding on you because you did not put it in here. Now, practically speaking, you're probably not going to renege on that statement. But if push came to shove, legally, the seller has no leverage against you, because what this says is that would be that would be what's known as parole evidence, or violate the parole evidence rule, which says that you can't add in if there's an expression of agreement that appears to be complete, you can't add in a prior agreement or contemporaneous oral statements to a ratified contract. And that's what this is. That's what this is here. So if it's something that you're discussing with your client when you're taking your listing agreement, put it in the listing agreement. That way, make it official. If you're dealing with an entity seller, like a trust, family revocable trust is the seller, you're going to check this, and you'll put in here the appropriate trustee's title, trustee, successor trustee, et cetera, et cetera. If you do that, you do not have to use the RCSD-S for seller. But if you don't do that, then you'll need to complete the RCSD-S form. And down here, you're going to put your name, your license number, the brokerage name, address, brokerage's license number, so on and so forth. How much time do I have left? I got about a little over 20 minutes. This form here, seller's advisory, really important because it breaks down when I do my listing agreements, with somebody, not only am I filling out the listing agreement, I try to knock off all the paperwork in one sitting with them. So I'll go through the listing agreement, you get that signed. Then I'm going to leave them to complete their transfer disclosure statement, their SPQ, all of that sort of thing, while I'm walking around the house doing my AVID. And then, but this form here, before they fill out their disclosures, this kind of goes over their disclosure duties and talks about general disclosure duties and statutory duties. General disclosure duties are things like, gee, there's a dog that lives, in back of my house, in the neighbor's house in back of mine, and every morning at 2 a.m., that dog just starts howling. That's a general disclosure duty. Another one, a general disclosure duty, would be, I painted the exterior of my house in January of 2022, or I painted the interior of my house in June of 2022, or I had a mold problem that was remedied by a professional mold company in 2003. Those are general disclosure duties. Statutory disclosure duties include, among other things, filling out your transfer disclosure statement, providing the natural hazard disclosure statement to the buyer. And that includes all of the disclosures of things like, gee, my house is in a high fire severity zone, my house is in an earthquake zone, my house is in a flood zone, my house is in an airport noise inundation area. Those are all statutory disclosure duties. You also have to disclose if somebody has died on the premises within the prior 3 years, unless they have died from AIDS. If they died from AIDS, you do not need to disclose that. Condominiums and other common interest subdivisions, if it basically is the property in an HOA. If it's in an HOA, the seller is going to have to provide HOA disclosure documents to the buyer. That's what this is talking about. If your seller is an investor, unless they're doing a 1031 exchange, there may be tax withholdings that have to be done at the close of escrow. You would want to give them that warning and then tell them if they're interested in learning more, they should consult with their CPA. Potential lead-based paint in pre-1978 built housing. There's a little disclosure there. We talk again about marketing considerations. We're going to, some homes, some agents will want to do pre-sale inspections, some won't. Talks about getting home warranties. Safety precautions. Again, it says your property is going to be marketed online. Lots of people are going to see it. Make sure you don't leave anything valuable that could show up in the photos. Make sure you don't leave anything valuable laying around your house, et cetera, et cetera. And finally, it says, you know, you're advised that you, Mr. or Mrs. Seller, not the broker responsible for the fees and costs of any to comply with your duties and obligations to the buyer of your property. So if the seller agrees to complete some repairs or give a credit for repairs or something like that, that's on the seller, not on you. And you can have the seller's sign and date here. Again, you're going to sign and date here. Let's see, you don't need to go through that. And that is it. And I do have time to take some questions.
Yay. Hi, Bruce. It's Melinda.
Hi, Melinda.
Okay, so going back to the submitting a confidential offer,
Mhm.
can you explain to me why that would be beneficial to my client?
Yes. So let's just say we're in one of those crazy markets like we had in the summer of 2020, right after the pandemic started. And if you were in the business back then and you had buyers you were working with, you would have found frequently that you go to make an offer on a property and you might be competing with 20 or 30 other people trying to get that property. And so everybody was trying to outbid everybody else. And if you were in a situation like that, it would be advantageous if you're making a really good offer. It would be advantageous to include a confidentiality agreement because you don't want that listing agent to be able to tell other agents that they're going to have to top your offer in order to get the property. Does that make sense?
Yes. However, if we're not submitting a great offer, wouldn't it just kind of piss the other agent off?
It might. If you're not submitting a great offer, then why bother going with the confidentiality agreement? I've
Got it.
actually, it's interesting, in auditing files in the office, I've only seen a few agents that have used the confidentiality agreements. So it's not being.
Well, I mean, it's always a question I ask the agent when submitting an offer. Where do your offers sit? You know what I mean?
That's right. And if you're a good agent, you're always going to ask that. I mean, I always did. If I had a strong buyer that had the money, I would, my typical question might be, where do we need to land in order to get this deal? And sometimes they tell you to, screw off. But it depends on the circumstances.
Okay, thank you.
You're welcome. Anything else?
Bruce, quick question here. See if I can ask this correctly. If there is few repairs, but the seller doesn't want to pay for it, and you as a seller's agent think that makes a big difference, and you want to pay and get those fixes done, how can I protect myself when it comes to those repairs? Hiring a contractor or a plumber to do a few minor fixes, let's say.
And you're representing the seller in this?
The seller, that's correct.
So first of all, you open up a can of worms here. Number one, if I were you, I wouldn't recommend contractors, because if the contractors mess something up, you're gonna be assuming some of that liability. But if you chose to do that, as of 2022, the Department of Real Estate has issued an edict, and if you recommend any kind of a tradesperson, contractor, plumber, electrician, general contractor, roofer, whatever, you are required to research through the Contractor State Licensing Board and confirm that that contractor actually is licensed and has insurance. Okay.
Yep.
So there's that. As I said, I would not recommend a contractor to do work, because if you've had any experience with contractors, most of them are flakes. I've had nothing but bad experiences with most of the contractors I've worked with. So I would leave it to the seller to find their own contractor or plumber to get work done. And also recognize that depending on the market, what's going on with it, the seller may not need to do repairs in order to get the property sold. Back at that market I was telling you about, the summer of 2020, if you couldn't sell a property as is, there was something wrong with you, because the market was just so flippin' nuts that anything was selling.
But how about if I want to pay out of pocket for those fixes as an
Say that
agent?
one more time.
How about if I want to pay for those fixes out of pocket?
You shouldn't do it.
Okay.
Number one, if you're doing that, you're choosing the contractor. What if your contractor messes something up in the house? What if you, let's just say there was some dry rot, and you decided you're going to get your contractor in there to repair the dry rot, and you're going to pay for it out of your own pocket. And it looks like, the contractor says to you, well, based on this, we're looking at about, $350. And they go out there and they remove some siding or remove the rotted wood, and all of a sudden everything else underneath it is rotted. And now you're looking at a $3,000 bill. Who's going to pay that?
Agent.
Yeah.
Awesome. Thanks.
Sure. Anything else? Speak now. All right.
I have a question, kind of just a general question, not necessarily about these items, but
Yeah.
when you're walking through these documents with a buyer or a seller, how do you know what to point out and walk them through and what not to?
Okay. So I try when I go through them, and I should tell you, my everyone has their own style of doing this. I had a business partner for many years, and she was an agent who explained things a lot less than I did. And towards the end of, before we shut down our brokerage, she got more and more like me in the way she went through the stuff. But for that reason, she could go through a listing presentation and list a house in about half the time that it took me. I went overboard to make sure that the people I was working with, that using my script that I used, that they understood what they were signing. And I viewed it as an opportunity to avoid misunderstandings and problems and mistakes down the road. And so, I might start at the beginning of the listing agreement, and I would just basically go through each of these things. I wouldn't go into them in like the detail that I went through, this section with you all, but I would just say, my commission that we're going to charge that will also cover the buyer's commission is going to be X. And this is your authorization for us to pay this amount and to advertise this as payment in the MLS for the buyer's agent. And then, I'd come down here and I'd, say, have you ever listed your property before, or at least in the last year? And if so, who? And move on down through here. And I'd say, on your solar system, are you, if they had a solar system, is your solar system leased or owned? And if they said it was owned, my next question would be, okay, I understand you own it, but are you financing that purchase? Well, yes, and you still owe money on it. Yes. And then I'd go through some of this stuff with them. And then, just go down through each of the sections and kind of summarize what it's saying, and why it's important to list in the MLS, and blah blah blah. And I wouldn't talk to them about the clear cooperation policy, but I would talk to them about the dangers that could happen if they leave something valuable on their walls, or if they leave, tax documents or bank statements out on the table. And I would caution them. And, I would say, look, I've never had a problem with one of my sellers saying something has been stolen from their home, but I don't want you to be the first either. So be mindful. You're going to have strangers, they will be accompanied by their agents, but you're going to have strangers coming through your home. My advice is make sure you keep all of your personal financial data stored away in drawers and cabinets. Don't leave anything laying on the table. No jewelry out, put it away somewhere. And I don't mean in a jewelry box sitting on a dresser. Put it somewhere else where, somebody's not going to be tempted to grab it. Like I said, I don't want you to be the first. And I would just kind of handle it that way and go through each of these things, talk about our duties, their duties, let them know that any expenses related to the marketing, I'm going to pay for. Anything, if you make concessions where you're going to, do a repair or credit the buyer with something, that's on you. And just kind of go through it one section at a time and just kind of summarize it with them. But I had the exact same script that I would use for every single client. So I would know if somebody came back to me a year later and said, well, you never told us this. Well, I know what's in my script. I know what I told them. And you just gotta practice it and do it so you internalize it and feel comfortable delivering that script when you're out at the meetings. And then I talk to them about the disclosures. I talk to them in much the same way that I talk to you about that. These are general disclosure duties. These are, statutory disclosure duties. And I try to do that before they sit down to complete their TDS and their SPQ. The other thing I talk to them about with the SPQ and the TDS is the arrangement of how the questions are phrased. Are you, seller, aware of? Yes or no. If you're aware of something, you check yes. You put a little reference to why that's a yes answer. But if you have no knowledge of something or you're not aware of something, the answer is always going to be no. So it doesn't mean that condition doesn't exist. It just means that you, seller, are not aware that it exists. If you explain that to your clients, it makes filling out those forms much easier for them. Okay, anything else?
Thank you.
That's good. Thanks, Bruce.
I hope you guys found it informative.
Oh, it was very good.
Class.
Awesome.
I'm glad you were able to attend. I've got all your names written down, and I will make note that you attended today's class. Thank you so much.
Thank you.
I hope
Thank you.
enjoy the rest
Thank
of your week.
you.
You're
You
welcome.
too.
Bye-bye.
Thanks, Bruce. Bye.